Major breaking news in the United States Court of Appeals for the Fourth Circuit, the Bianchi versus Brown case dealing with Maryland's quote-unquote assault weapon ban. Major order has thus just been issued by the Fourth Circuit. Quite surprising to see this kind of an order. It's going to be actually backfire on the anti-gunners. I'm perplexed as to what happened here. You're not going to want to miss this breaking news segment in 1 minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of many books, including Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, we have breaking news here. As you know, the state of Maryland has banned quote-unquote assault weapons, which are AR-15 semi-automatic rifles. This has been challenged for many years in a case called Bianchi versus Brown. It went up to the U.S. Supreme Court. It's now back down in front of the United States Court of Appeals for the Fourth Circuit. You may recall that this is the case where a panel was getting ready to issue, in all likelihood, a ruling in favor of the Second Amendment, knocking out Maryland's quote-unquote assault weapon ban, but then there was games being played, as I predicted, by the Fourth Circuit Court of Appeals, which is a terrible anti-gun court and very, very activist. It's not just that they're anti-gun, they're activists when it comes to being anti-gun, and they basically internally granted en banc review when nobody asked for it to prevent that panel decision in favor of the Second Amendment. That's almost certainly what happened here. So now the case is up on en banc review. En banc review in the Fourth Circuit means that all the active judges in the Fourth Circuit are going to be able to weigh in on this case. It is a anti-gun court. Even a couple of the Republicans that are Republican appointees are terrible on guns. So we're going to likely lose this en banc case. You may also recall that the Bianchi case, there is a petition for cert before the U.S. Supreme Court, and because this is a final judgment case, there was a final judgment against the Second Amendment plaintiffs. There is an argument and a chance the U.S. Supreme Court may grant cert on this, which would be the best case scenario. And just to remind everyone, the parties involved in this case are not just Mr. Bianchi, but also the Firearms Policy Coalition, the Second Amendment Foundation, and the Citizens Committee for the Right to Keep and Bear Arms. Good luck to all of them. So anyway, the major breaking news is the Fourth Circuit has just issued an order that is quite strange before the en banc argument, which is coming up, I believe, later in March. Specifically, this is what the order says. This case is scheduled for oral argument on March 20th, 2024. The parties are directed to file supplemental briefs specifically addressing the following issue: whether the inquiry into a weapon's common use occurs at the first step or second step of the framework articulated in NYSERDA versus Bruin. In answering that question, the parties are to address who has the burden of establishing a weapon's common use. The parties may submit simultaneous briefs not exceeding 10 pages on or before Tuesday, March 12, 2024. Okay, so that's what the order says. Now, this is quite interesting, and this is very, very bad for the anti-gun movement in America, because there is no dispute, if you're earnest and serious, and you read the Supreme Court case clearly of Heller and Bruin, that the burden to show that a weapon is not, I repeat, not in common use, is with the government. This is a very straightforward analysis. This is going to give, I suspect, the Second Amendment proponents, like the Second Amendment Foundation and the Firearms Policy Coalition, it's going to give their attorneys the opportunity to lay out in great detail that indeed that the burden is on the government to show that a weapon, in this case AR-15s and semi-automatic rifles, are not in common use. Just to jog your memory, the way the Bruin analysis works, which is really just the Heller analysis, has already been done when it comes to arms ban cases, because the Bianchi case is an arms ban case, meaning a ban on AR-15s, a ban on semi-automatic rifles. It's an arm ban case in the same way that Heller was an arms ban case dealing with the District of Columbia's ban on handguns. So we already know the constitutional test because the Supreme Court already did the text first, shifting the burden to the government, and then the historical analysis in gun ban cases. There's a lot you can debate about it, but the one thing you cannot debate if you're a serious person reading this law honestly, is that if the government fails to show that a particular weapon or arms is not in common use, then it simply cannot be banned. Now, this is very important because remember, I did a video a few weeks ago specifically on the text of the Second Amendment. This is very important. I know it's sometimes boring and very geeky, but I give this information to you because it's mission critical. Here is an example. Specifically, Bruin talks about that you start with the plain text of the Second Amendment, and that's where your starting point is. And it's crystal clear from the Heller case, which defined arms as anything that can be used offensively or defensively. Specifically, Samuel Johnson, the British lexicographer that did it, the early English dictionary at the time of the founding, he specifically says that all arms are, quote, weapons of offense or armor of defense. Anything that can be used offensively or defensively. Noah Webster, the American, agreed with this. So there's no doubt that AR-15s and semi-automatic rifles are arms at the plain text, which means what happens? You know what happens? The burden shifts to the government. Now here, because the burden shifts to the government, the constitutional test for arms ban cases has already been established. In the Heller case, it's the in common use test, meaning the government has to show it's not in common use. That's the only way they can win, to show that something is dangerous and unusual, which is the historical approach here. So again, once the burden shifts to the government at a plain textual level, now the government has to do the historical analysis. So if you look at the question by the Fourth Circuit here, they ask, does the inquiry into the weapons common use occur at the first step or the second step, and where does the burden lie? The reason why they've raised this issue is they're trying to understand, does the in common use test occur at the plain text level, where the burden is arguably on the Second Amendment plaintiffs, as opposed to the in common use analysis occurring at the constitutional text level, at the constitutional test level, at the historical level. Now remember, I've told you this for over a year. The anti-gun movement wants the in common use test at any of these tests to occur at the plain text level, because the burden has not yet shifted to the government. But it's clear, if you look at the Heller case, that the historical analysis of what is in common use and dangerous and unusual, all of that occurs at the historical level. Because first of all, the common use requirement was the result of two things: that arms that were dangerous and unusual could be restricted in terms of the carriage. That was done as part of Heller's historical analysis. It had nothing to do with the plain text, because at the plain text, arms are simply defined textually as anything that can be used defensively or offensively. So at a textual level, there's no debate at all that these semi-automatic firearms, these semi-automatic rifles, these AR-15s are arms, which means how do you even talk about in common use? It obviously occurs at the historical level, because if you read the Heller case, again, the discussion of in common use arose from the discussion of dangerous and unusual laws and dangerous and unusual weapons, and could they be restricted in terms of carriage? That was all part of Heller's historical analysis, which occurs again at the historical level, not at the textual level. And because it occurs at the historical level, guess what? The burden of proof is on the government. The second thing, of course, is there's a discussion about people could bring arms, to the militia duty that were typically used for lawful purposes, because they could bring these commonly owned arms to militia duty from their private homes. That also was part of Heller's historical analysis, where again the burden lies. So the bottom line is this: that Heller has talked about. Heller makes it crystal clear that the burden is on the government to do the historical analysis and to show that they're not in common use. So this question from the Fourth Circuit, I don't know if the anti-gun judges on the Fourth Circuit thought this was a great idea, but I suspect this may have been pushed out by the pro-Second Amendment judges on the Fourth Circuit Court of Appeals, because this question presented is very, very favorable to the Second Amendment community. Why? Because the answer is so crystal clear based on the Heller and the Bruin precedent as to what's going on here. So it's almost as if somebody on the Fourth Circuit wanted it to be crystal clear, so that the anti-gun judges on that court cannot wiggle around where the burden lies and what the in common use test means, and that is part of history. But again, only time will tell. I think this is a good development. I'm not saying we're going to win Bianchi in the Fourth Circuit because they're terrible anti-gun judges. I think they will make up anything they have to make up to avoid ruling for the Second Amendment. That is my prediction, and I'm pretty sure I will be right on this. But anyway, despite their desperation and their dishonesty in terms of their interpretation of law, which is what I'm guessing will occur, maybe I will be pleasantly surprised and I will turn out to be wrong. I hope so, but my guess is there will be games played by the Fourth Circuit Court of Appeals, allowing them to justify a ban, improperly justify a ban on the Maryland assault weapon law. But nevertheless, we'll see how that plays out. Okay? All right, folks, I'll keep you informed of the Bianchi case. Make sure you follow me on X at 4Boxes Diner. And of course, make sure you follow me here at the 4Boxes Diner. And we will see you again soon here. Yes, indeed, at the 4Boxes Diner.